In today's video, we will look at the features of a valid offer and acceptance. In contracts law, offer and acceptance are fundamental elements in the formation of a valid contract. Here are 5 key features of a valid offer and a valid acceptance. 1. Clear and definite offer. An offer is a proposal made by one party, the offeror, to another party, the offeree, indicating a willingness to enter into a binding contract. The offer must be clear, definite, and communicated to the offeree. It should outline the terms, conditions, and essential elements of the proposed agreement. These include, for example, information on the goods or services to be provided, the quantity, quality, price, and any other relevant terms and conditions. The terms should be clear and definite enough for the offeree to understand and accept them. 2. Intention to create legal relations. For an offer to be valid, it must demonstrate an intention by both parties to create legal relations. This means that the parties involved intended to be legally bound by the terms of the contract. Social invitations, for example, an invitation to come to a party, are generally not considered offers because they lack the necessary intention to create a legally binding agreement. If the parties have explicitly stated the intention to be legally bound, whether orally or in writing, it indicates a clear intention to create legal relations. Express contractual terms or statements that outline the binding nature of the agreement are strong indicators of intent. Agreements made in a commercial or business context are typically presumed to have an intention to create legal relations. The presumption is that parties engaging in commercial dealings intend to be legally bound by their agreements. 3. Communication and acceptance of offer. Communication of an offer is the initial step in the formation of a contract. The offeror, the party making the offer, must clearly communicate the terms of the offer to the offeree, the party to whom the offer is made. The offer should be communicated in a manner that is reasonably expected to reach the offeree. An invitation to treat is not an offer, but an invitation to negotiate or make an offer. It is a preliminary communication that indicates a willingness to receive offers. Examples of invitations to treat include advertisements, price lists, and display of goods. They are generally considered as invitations for others to make offers. 4. Mirror image rule. The acceptance must be a mirror image of the offer, meaning that it must match the terms of the original offer precisely. If the offeree attempts to change or add conditions to the offer, it is considered a counteroffer, terminating the original offer and requiring acceptance from the original offeror. There must be a meeting of the minds between the offeror and the offeree. Acceptance must be unconditional and mirror the terms of the offer. 5. Communication of acceptance. Acceptance must be communicated explicitly and clearly to the offeror. Silence or mere inaction generally does not constitute acceptance unless there is a previous agreement or course of dealing indicating otherwise. The mode of acceptance should conform to the method specified in the offer, or if no method is specified, it should be a reasonable method based on the nature of the transaction. For example, if the offer was made by mail, acceptance by mail would typically be considered valid. Acceptance should be communicated to the offeror or the authorized agent. If acceptance is directed to an unauthorized party or a third party, it may not be effective unless the offeror has authorized the communication to be made through that party.